Good afternoon, everyone. Thank you for joining us for today's online talk. For those who are here early, thank you for waiting patiently. While waiting, we have a short video from the firm to show you.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome everyone once again. Thank you for joining us for today's online talk. And the title is The Offence of Criminal Intimidation and Rights During Arrest, Remand and Bail. Hello everyone, my name is Hannah and I'm a senior associate with the firm and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Mawing Kwai & Associates is a mid-sized law firm that was founded in 1985 by Dr. Mawing Kwai. Our able team today comprises 28 lawyers and a support team of 15. Dr. Ma today is a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department and a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment or industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups here indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution team. By way of background, today's talk is part of Mawing Kwai & Associates online talk series. We have been organizing these talks in our office since 2013, some of which were broadcasted live. But with the COVID-19 MCO in 2020, we moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. This is our fourth talk this year in our series. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for complimentary legal consultation. I will give you the details at the end of this talk. Now, let me introduce to you our speaker. Ms. Vivian Fan is a fellow senior associate in the firm and heads the criminal team here. Her other practice areas includes general litigation, debt recovery, construction, land acquisitions, probate, and administration of estates, contractual disputes, and tenancy disputes. The top points that Vivian will cover today are: what is criminal intimidation and when is it an offense? What amounts to an arrest and what are the rights of an arrested person? What is remand and how long can one be detained? And finally, when is an arrested person entitled to bail? If you have any questions, please don't hesitate to type them in the Q&A box below, and Vivian will take these questions at the end of the talk. Without further ado, over to you, Vivian.
Good afternoon, everyone. Thank you for taking your time off today to attend our MWK online talk series on criminal intimidation and your rights during an arrest, bail, and remand. So the first top point I will share with you today is on the offense of criminal intimidation and when exactly does it amount to an offense. The offense of criminal intimidation is stipulated under Section 503 of the Penal Code, which states that whoever threatens another with any injury to his person, reputation, or property, or to the person or reputation of anyone in whom that person is interested with intent to cause alarm to that person, or to cause that person to do anything which he is not legally bound to do. There's a lot of words before you, I'm sure, so let me just break it down for you. The Penal Code has given a brief explanation that a threat to injure the reputation of any deceased person in whom the person threatened is interested. It also falls within the offense of criminal intimidation. And a brief illustration that has been provided in the Penal Code is that, for instance, A, in order to induce B to desist from prosecuting a civil suit, threatens to burn B's house. A is guilty of criminal intimidation. B wants to sue A for a civil debt, and A threatens B to say, if you ever sue me, I will burn down your house. So that, on its surface, amounts to criminal intimidation. We'll look at a few news reports for you to have a general idea on what exactly is this offense about. So the punishment for criminal intimidation is provided under Section 506 of the Penal Code. The general punishment is that it is imprisonment, which may extend to 2 years, or a fine, or both prison and fine. However, if the threat is to cause death or grievous hurt, or to destroy any property by fire, then the sentence is imprisonment for a term which may extend to 7 years. And if the threat imputes chastity to a woman, the offense is punishable with a term which may extend to 7 years or a fine or both. So here we have one of the recent news in June 2021 is where a man threatens to burn his family home. When the incident happened, he also pointed a knife to his mother's throat. In a situation like that, if a police caught you in that situation, then on the surface, you may be charged under Section 503 and 506 for criminal intimidation. And this one, I'm sure some of you have seen. In 2019, there was a death threat against a lawyer, Shahrazad Johan. He received a message that was sent to his phone, which read, if you chase away Dr. Zakir Naik, at that time, there was news about him preaching. The threat says, I will find you till I get you, and I will separate your pig head from your body. This I swear on Islam and the Malay race. If you dare, try it. This itself amounts to a threat, and you may be liable for criminal intimidation. Another 2 news report for you to understand is in 2018, during a quarrel with an accused wife, he used abusive words such as threatening to slash their children, and all of this which was witnessed by their youngest daughter. In situations like that, because there's elements of domestic violence, the courts are more strict in terms of punishment, and in this case, the accused was convicted and sentenced to 2 years imprisonment. Whereas, in another news report in the same year, a man threatened to cause injury by using the word hentam to his brother-in-law. By merely just using the word hentam instead of any acts of violence, such as what I just shared with you earlier, he was only fined with 5,000 ringgit. So to have a deeper understanding of how the courts have viewed this offense, I will share with you a few court precedents and the punishment that have been given by the courts in a myriad of situations. So the first one I will share with you is a very recent case in January 2022, public prosecution versus Muhammad Azan Taldari. So in this case, the accused threatened his wife by saying, as you can see before you at the screen, he said to his wife, "Kamu memang babilah, memang kau kena ajar ni, kami ingat aku takut ke? Sikit je lagi aku nak hapuskan kamu semua." So the threat here is hapuskan kamu semua, to destroy all of you. So in this case, the magistrates actually sentenced him to a fine of 2,005 ringgit only, of which then the prosecution appealed. The prosecution says 2,005 ringgit is too light of a sentence because in the situation where the words were uttered, there were history of the accused abusing his wife. He has hit and slapped and kicked his wife before. There were history of him pressing her face against a bed. And there were evidence that his wife has suffered physical and mental abuse from all this domestic violence that has happened throughout their relationship. So more importantly, when the matter went to the High Court on appeal, the court actually took cognizance of the fact that the accused was a former army. So because he is a former army, he ought to have practiced the values that he had learned throughout his service. To commit what he actually committed, he deserved not just a fine, but the High Court sentenced him to 10 months jail instead. And the second precedent we have here is very interesting. September 2021, the accused scolded his wife in an argument and he uttered the words, "Kau nampak kayu ini? Aku pukul kau guna kayu ini nanti." So he threatened to hit his wife with the wood that he was holding in his hand. And then after he uttered those words, he chased his wife and his children out of his house. You may think that in this situation, he had a wood in his hand, there was some form of violence, and he was obviously threatening to hit his wife. Any objective person would have expected him to use the wood to hit them if they hadn't ran out of the house. But interestingly, in this case, the magistrate court actually issued, instead of a fine or imprisonment, he actually sentenced him to a bond of good behavior under Section 294 of the Criminal Procedure Code. So under this section, the court can actually use his powers to just order you to serve community service together with a bond instead of sending you to prison. But in what situations can this good behavior bond be ordered? This is what the judge said. He said, to sum up, the accused person was a first offender. He pleaded guilty at the first instance, and he had health conditions which does not warrant him to be sent to jail. He was suffering stroke at that time and tendencies of stroke. The court sentenced him to a bond of good behavior of 800 ringgit with one guarantor for a period of 12 months with an additional term that he reports to the police station twice a month during the period of his bond. So the court here has actually taken into consideration the conditions of the accused and is of the opinion that by him serving community service, it is a form of rehabilitation and deterrence of him committing the same offense again. The third case that I would like to share with you is also quite a recent case. What happened is that this is quite common. He was actually on his way home with his wife and children on his bike. Then there was some friction with another car on the road. Then they got into an argument. Then this accused called his brother. His brother came to the incident with his bike. So what he did was he parked his bike in front of the car and the brother parked behind of the car. So they were sort of blocking the car. And then the accused angrily during the argument said, "Bodoh lah tarak license ka, mau mati ka." So there was some form of death threat here, threatening to, do you want to die? So what happened was that after trial, all the evidence were adduced. The magistrate actually discharged and acquitted the accused because he found that there was no criminal intimidation. Interestingly, not to our surprise, the prosecution appealed. Appeal brought the matter to High Court. The prosecution said that in these circumstances, there was a death threat and the victim, the car rider, was in fact very scared of what was actually happening. He was scared that, he may be injured, he may be harmed. When the matter went to High Court, the High Court actually agreed with the magistrate. The High Court said that the prosecution has failed to prove there was any intent to harm the car rider. There were no weapons at scene, and the only sentence that was uttered was what I said just now, which is, "Do you want to die?" There were no fighting, physical abuse, anything involved. And interestingly, the court said these kind of words that were uttered in the spur of the moment were commonly uttered in car accidents or on the road by car riders or bike riders. And hence, there was no intent that there was actually going to be any physical harm involved. And this fourth case we have here is not very surprising. What happened was the accused pointed the gun at a victim's lips and he threatened that he will kill all of them throw their bodies in the river. And in addition to that, the accused actually said that he was an ex-soldier and he will use all his force and all his experience to do what he can to injure this victim. When those words were uttered, when he was pointing the gun at the victim, he actually pointed his gun to a nearby dog in a compound and he shot the dog. Then he pointed it back to the victim and threatened the way he did, as I've shown you. So in this situation, clearly the court said that was a real threat, that if the victims do not do what they were asked to do, it is very likely that the accused will use the gun to shoot them. And this is in addition to the fact that he actually used a gun on the dog previously. So taking everything into consideration, the court found that there was some serious threat of injury or death and sentenced him to 2 years imprisonment. As you can see, what we can glean from the cases before here is that the punishment ranges from a fine of 2,005 ringgit, 5,000 ringgit, to imprisonment of 2 years, or even just a good behavior bond. And the reason why these punishments differ, it's because it's based on the particular facts of the case, whether there was any real threat involved, whether there was any intent to cause alarm when those words were said. An important thing to note here is that, as I shared with you earlier in the car accident, it doesn't matter if the victim was actually scared. It doesn't matter if the victim actually believed that he will be harmed or that he will be hurt by the accused who said those words. What the victim's state of mind does not matter. It's actually what an objective person would actually feel or react if those threatening words were said to him or her at that instant, and that is important. So the fact that the court does not care whether the victim was actually scared, whether the victim was actually traumatized, all these are not considerations as to whether the offense was actually committed. Based on all these cases, I think something to take note is that any words of anger may have been said in the spur of the moment when you're angry, when you're frustrated in an argument especially. And of course, as much as you want to avoid that, in the event the person who heard those words lodge a police report against you, then the prosecution will have to prove that you actually had the intent to cause alarm to the person you said those words to. So that's some general idea on what this offense of criminal intimidation is. And I will now move on to share with you on arrest, bail, and remand. So what amounts to an arrest and what are the rights of an arrested person? I think all of us may or may not know what are our rights and what we can do and cannot do when we are arrested by a police officer. And it's important to know your rights because your rights is actually entrenched in Article 5(1) of the Federal Constitution. It says, "No person shall be deprived of his life or personal liberty save in accordance with law." So if you've been arrested, or if you're under a police arrest, your personal liberty has been deprived or is being deprived. In such situation, it will contravene your rights, Article 5(1) of the Federal Constitution, if the police did not act in accordance with law, meaning he misused his police powers or he did not arrest you as how he should have done based on the Criminal Procedure Code. And what all this means, we'll have a look at it now. So what amounts to an arrest? It is when the police tells you he is arresting you, like what we see in movies, you're under arrest. Or he doesn't even need to say that. He can just restrain your movement, i.e. stop you from going anywhere that you were headed to. Or when he handcuffs you. Can the police use force to arrest you? Yes, they can. But if and only if you resist arrest and if you make their job difficult, then they can use force to arrest you. Or say if you're running away from them, they can use force to arrest you. And what do you need to know? So, of course, you need to know whether the police officer has authority to arrest you. And how do you know? You have to ask for their ID and their name. In a lot of situations, when you come across a police officer or police approach you and say they want to bring you back to the police station, you have the authority, you have the right to ask him for his name and to ask him to show you his ID card. A few things to take note is that if his ID card is red, he does not have the right to arrest you because he's been suspended, and all the other colors are not of significance. But of course, in situation where the police is suspended and has a red ID card, it's more likely than not that he will not show it to you. So what happens, you may ask, what happens if the police refuse to show me his ID card, refuse to cooperate with you? Then in such situation, you can just take down his name, and the police station of which he is attached to. Alternatively, instead of just following him blindly in his car, you can say, okay, I will cooperate with you. I will follow you to the police station. right? So this is to avoid situations where they are fraudster pretending that they are police officers when in fact there's possibility of them bringing you to some unknown place, right? So always ask for their name and the police station of which they're attached to. Secondly, you need to know your rights if you're being arrested. And what are your rights? You have 5 rights that you need to remember. You have the right to be informed, right to communicate, right to consult and be defended, to defer any questioning, and the right to be released after 24 hours. So right to be informed. So when you're arrested, the police officer must inform you of the grounds of your arrest, unless you're caught in the act, say, you're caught stealing, you're caught burning down a house. So obviously there's no need to tell you the grounds of your arrest. But in all other situations, they have to tell you the grounds for your arrest. Right to communicate. So upon arrest, you have the right to call your friend or your relative or your lawyer, but they can deny you the right if the police is of the opinion that, you may tell your accomplice that the police is after you or after your accomplice, or the police thinks that there's a risk that you may tamper the evidence, destroy any evidence, then they can deny you of such right. So upon arrest, you say you want to call your friend, your relative, and if they say no, then you have the right to ask them why no. Thirdly is your right to consult and be defended. You have the right to seek legal advice of any lawyer of your choice. And the police must ensure that you have the proper mode of communication with your lawyer. So say if you don't have your phone with you, the police officer must provide you with telephone at the police station in order for you to call your lawyer. So until you speak to your lawyer, you have the right to defer any police questioning or recording of any statement. The police cannot force you to take your statement or interview you until you have sought legal advice. So don't feel pressured or don't feel forced that whatever the police ask you to do, you have to follow, right? You have to remember your rights. You have the right to say no until you seek proper legal advice. Lastly is your rights during police interview. So I'm sure we've all heard of the right to remain silent. Yes, you have the right to remain silent, but especially if the answers that you will give will expose you to a criminal offense. So, things like I was at that house when the incident happened, or any admission of guilt, you don't have to do it during the interview, right? And during the police interview, what happened is that questions will be put to you by the police officer. As you answer, he'll type your answers down. So at the end of the interview, he will print it out. He will show you what you have stated. And then he will ask you to confirm whether what he has stated, what he has printed out is accurate. If it's accurate, then you sign. This is very important because as much as this statement or whatever that you said during the police interview cannot be used against you in court later, what you said during the police interview may actually harm your case later, or you will have to go through criminal proceeding when you actually do not need to. So during the police interview, don't succumb to pressure, don't give answers which the police force you to, and don't sign the statement if whatever is stated on the paper was not said by you. And this is something additional. So these are situations where the police officer will call you, the IO, i.e. the investigating officer calls you and says, he wants to interview you this particular incident on this day. Then what do you need to do? Most of the time, you should cooperate. In fact, all the time you should cooperate, because if you don't cooperate, they can issue a warrant of arrest and arrest you at your house. So you can cooperate. You ask which time, which place, find a common time, suitable place, find a lawyer and go with your lawyer instead of avoiding these calls or anything like that, because that may lead to even more trouble than what it actually may have been. What is remand and how long can a person be detained upon arrest? So after you're arrested by a police, how long can they keep you for? 24 hours only, unless it is an offense under the Drug Dependence Act or the Immigration Act. Then they can detain you for 14 days, a minimum of 14 days. So total of 24 hours. And then what happens after the 24 hours? You've seen police detaining people for more than 24 hours. It's because there are two situations here. After the 24 hours, the police either release you or the police must bring you before a magistrate and apply for a remand order to extend the detention period for further investigation. And this is literally most of the time because they will give excuses such as, I need more time to investigate. I need more time to interview you. I need more time. I need to keep you longer for my investigation purposes. And most of the time, they will ask for the maximum. What is the maximum? So the maximum is, the first remand order is 4 days. right? They bring you to the magistrate, they ask to remand you for 4 days. Or if it's an offense which is liable to punishment of more than 14 years, they will ask for maximum 7 days. And then after that, they can extend again for 3 days, more than 14 years offense, another 7 days. So it's 4 days, 3 days, total of 7 days, 7 days, 7 days, total of 14 days. They will give all sorts of reasons. There was no time. The police haven't got the time to interview you, or your drug test is not out and things like that. So can you be represented during a remand application? Yes. And what do we lawyers do? We actually oppose the remand application before the magistrate, and we will tell the court or the magistrate why you shouldn't be detained any longer than 24 hours, or why you shouldn't be kept for 4 days, right? And most of the time, so what happens is that they won't tell you. Most of the time, they're very sneaky. They won't tell you when is the remand application, when they will bring you to the magistrate, because then obviously you will get a lawyer and oppose the remand application, right? During the whole police arrest, detention, 24 hours, you have to find out from the IO, when will you be brought to the magistrate? What will happen next? Can you speak to your lawyer? Can you call your lawyer? All right. And then you inform your lawyer that the remand will be on this date at this time. Please come and oppose the application. Otherwise, you will have to stay in a police station or in a lockup for as long as the police ask for. And what happens at the end of the detention period? They must either release you, right, if there's not enough evidence to charge you, or they must bring you to court to charge you. And now we come to court when is an arrested person entitled to bail. So they bring you to the court to be charged. When you're in court, the charge sheet will be read to you. You're asked whether to plead guilty or not. Mengaku salah ke tidak. Once you plead guilty, the court will record your conviction, then proceed to sentencing. And that is where either you yourself or your defense lawyer or your lawyer will mitigate and ask for a lighter sentence. If you plead not guilty, meaning you want to claim trial, then the issue of bail will come into question, whether you can be released on bail pending the trial or whether you can't. So what is bail? Bail in simple language means security taken from a person to appear on a fixed date before a court. The meaning of the word bail, as ordinarily and commonly understood, is to set free a person who is under arrest, detention, or some kind of restraint by taking security for his appearance. So it depends whether the offense is a bailable, non-bailable, or unbailable offense. If the offense that you're being charged with is a bailable offense, then you are entitled to bail. It is as of right. They cannot deny you bail, right? And if it's a non-bailable, the court has a discretion. And unbailable, the court cannot grant you bail at all, such as very serious offense, terrorism. So bailable offenses, they are usually less serious offenses, which carry lighter sentences, such as imprisonment of less than 3 years or just a fine. Non-bailable offenses is usually murder, and the court has a discretion whether to grant you bail or not. They will deny you bail if, say, there's a risk that if you're out there, you may harm more people, or you will destroy all the evidence. Then it is, or you will abscond. They will not be able to find you after that. Then it is very likely that bail will not be granted to you. How does the court decide whether to grant bail? So if it's an offense which is punishable by death or life imprisonment, the court will not grant bail if there are reasonable grounds to believe that you have committed the offense, unless if you are under the age of 16, a woman, or if you're sick. If the offense is not punishable by death or life imprisonment, then there are several factors that I mentioned earlier: seriousness of the offense, danger of absconding, not appearing, danger of repeating it, or tampering of evidence. So here, the court will not grant you bail if it's terrorism, kidnapping offenses, or any offenses under Firearms Act. So here, who can be a bailer, right? An adult must be above 18 years, Malaysian citizen. If it's a non-citizen, then the court may impose more conditions. And if the accused is a foreigner, then the bailer has to be a Malaysian citizen. If, say, any of your friends, relative, or you has been arrested, brought to court, charged, you need to contact your family members or your friends to be there, because otherwise no one can bail you out. Examples of bail conditions: bail sum, they will release you if you deposit a sum of money in court, and the sum of money deposited is usually not more than the maximum fine that the sentence provides. You have to bring a guarantor, and they call it penjamin, or they can ask you to report to the police station on a monthly basis or a weekly basis. And some situations, they will take your passport. You will have to surrender your passport if there are risks of you going to another country and absconding. And what happens if you breach conditions of the bail, i.e. you do not attend court as and when you have to? Then the bailer will be summoned to court to answer to the judge. The bail sum will be forfeited. The court will issue a warrant of arrest, and the court may revoke bail in future appearances. I've shared with you a general idea on the offence of criminal intimidation and what you can do, shouldn't do when you're arrested by a police officer, and what happens when you're brought to court to be charged. So in all situations, you have the right to call your family members or your lawyers so that you're protected, so that your rights are protected, all right? Especially no matter how small the offense is, right? Don't succumb to the pressure of just pleading guilty to get out of it. Most of the time, we will advise you on whether, the evidence is strong enough, whether you should plead guilty and all other things before you plead guilty. Okay, because once you plead guilty, it's actually a point of no return. Thank you for listening.
All right, we do have a number of questions. Unfortunately, we may not be able to answer everything. That's okay. We will try to answer as much as we can. And I also want to remind the participants to type your questions in the Q&A box as opposed to the chat box. There is a question here from an anonymous attendee. It says here, do we need to produce evidence of threat from the other party? What if there is denial? What to do if there is no evidence? And if it's verbal and unrecorded?
I think I see a similar question in the chat box as well, whether there needs to be some evidence of recording or documented, written down. Well, of course, if there is, it would be good, right? So if there's no evidence, nothing, no recording, no written threat, then it's basically I say, you say. Okay, but in most circumstances, if there is a genuine threat by the other person, most of the time, they will not only threaten once, they will threaten twice or 3 times, right? So I will advise clients to always either record the phone call or have it via text. Then you have something with you. But what happens then if there's no evidence? Then, of course, it will be he say, she say. And then the court will decide based on the evidence the prosecution has, i.e. the witnesses, whether there are any history of bad relationship, history of physical harm, history of verbal abuse before. So the court will look at this to see who to trust.
So what you're saying, Vivian, is that if in the absence of evidence, there are other evidence that the court will look at, i.e. witnesses, as well as past conduct and past history?
Yep.
Okay. I think that would also answer Miss Stephanie May's question. Now we will go to the next question. If the police, whether in uniform or in plain clothes, refuse to produce their ID, would I then be entitled to not comply with the order promulgated?
If they refuse to produce their ID, as I mentioned earlier, most times they will actually refuse unless you have a very cooperative police officer. Then, like I said, you can either say, ask for their name and the police station of which the police officer is attached, or you can say, okay, I will follow you to the police station or I will meet you at the police station. That is complying with the police officer's instructions, at the same time, not be at risk of a fraudster police officer.
The next question from the same person, Muhammad Khairul Anwar. For the 24 hours of initial arrest, from what time is it calculated? Is it from when you were picked up from the street, or from when you enter the balai, or from the time you're actually put in the lockup? When does the 24 hours start?
So the 24 hours starts upon arrest, meaning when the handcuff is on that person, on the accused, or when the police says you're under arrest, or when you get into the police car. That is the 24 hours starts then. But the time period taken for transport, let's say from place A to the police station, is not included in the 24 hours.
Now, what happens if this 24 hours is during public holiday or the weekend?
The 24 hours take into consideration public holiday and weekends as well. So let's say you're arrested on Friday, 11 a.m. So you're asking if Saturday and Sunday is counted in the 24 hours? Yes. So it's counted. And then upon the expiry, they will go to the court magistrate and ask for an extension because it falls on a weekend. What is the legal recourse if one is kept longer than 24 hours? Okay, so if one is kept longer than 24 hours, then clearly there's a breach of your rights under Article 5 of the Federal Constitution. And then that's where the lawyer comes in and says you have to be released. Well, apart from that, of course, you can sue the government or the police for illegal detention, but that is a whole course of proceeding which you may or may not want to proceed with. Alternatively, you may also lodge a complaint against the police.
Flowing from that answer on public holiday earlier, is the magistrate court for remand open 24 hours?
So they don't actually have to bring you to a court, a physical court. The magistrate can actually come to the prison or the lockup or the police station. So they have a station place there.
Are arrest procedures and rights for persons under arrest same for the arrest made by law enforcement agencies such as MACC? Is there something you want to answer in this?
Yes, the procedures and the rights are the same. Detention period is the same. But MACC has certain provisions that may allow them to detain you longer than the first basic 24 hours or 7 days. So it depends which provision they are investigating you under.
What are the legal recourse if one is arrested, remand for 3 days is obtained, and later there were no charge made?
Well, because I believe that the detention or the remand was made accordingly. They got a remand order from the magistrate and then detain you for 3 days and then says, okay, no evidence, you can go home now. I will not charge you. It's not illegal. The detention is not illegal because they obtained the order from the court to detain you. But most of the time, I get questions from clients asking, I was in a police station for a few days. I was in fear. And then now the police is not charging me. Isn't that unfair? What can I do? Well, unfortunately, the detention is not illegal. So you can't sue for illegal detention. The brief answer to that is they will say that it's your responsibility to aid police investigation.
Hi, Vivian. You mentioned about recording phone call. Is this legal or admissible as evidence?
Oh, yes, definitely. So we have previous cases where client actually recorded the call with another phone, and that recording was used by the prosecution. Of course, the prosecution will have to verify who recorded the phone call. The prosecution will have to produce a transcript, or if the language of which it was spoken was not in English or Malay, then, they will have to send it for translations. So yes, it is admissible as evidence. In fact, it's very important when it comes to criminal intimidation offences.
This will be final question from the Q&A box. Hi, Vivian. Is the police officer allowed to keep your identity card and other possessions?
Yes, if you're arrested, brought to the police station, most of the time, they will keep all your belongings. They will ask you to surrender your phones, your IC and everything, and they can keep you until they can keep the identity card until they release you. Similarly, if, say, they stop you at a roadblock and they say, come with me to the police station, you have to follow them to the police station. And during that period of transport from place A to police station, they have the right to keep your identity card. This is during arrest. So they have to return all your belongings to you once they release you.
What if the recording is done in secret?
If it's secretly recorded, whether it can be admitted as in evidence?
Yep.
Yes. Most of the time, the recordings are done in secret anyway.
Yeah.
So as long as you can verify that whoever's voice belongs to the accused, then yes, it is admissible in evidence.
Wow, that was really well done. Thank you, Vivian, for your insights. Had a really good question and answer session. So before we conclude, I have a few announcements to make. First, we have an upcoming talk on trademark infringement and passing off. This will be delivered by our partner, Ms. Leslie Lim, and myself. We will be speaking on intellectual property. So if you have anyone or if you yourselves are interested, please join or sign up for the talk. The QR code is there. Secondly, please fill in our feedback form and tell us what you thought of our talk today. The link to the form will also be posted on the chat. We will appreciate every feedback that you've given us so that we can improve future or cover topics that you are interested in. Third, do follow or like our social media accounts. As you can see from the screen, we have various social media accounts. Whichever that you have access to, you are very welcome to follow us for updates. And finally, if you have any questions at all or any matter that is specific to you and you would like to speak with our lawyers, we offer a 30-minute complimentary consultation over telephone or video conference. Or if you prefer in person, then appointment can be made. Please fill in the form. You can see from the link there, or scan the QR code. Thank you for joining us. I hope you enjoyed the session. Thank you again, Vivian, for that really insightful talk. And I hope all of you are come out of this talk a bit wiser about your rights.